Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. Learned counsel for the appellant accused submitted that the learned special judge failed to appreciate the evidence correctly and erred in holding the accused guilty of the offences. The SGL information concerning the securities repurchased by the UCO Bank on 5th April 1991 was received on 12th April 1991. Since there used to be a number of transactions by the clients or brokers and the repurchased SGL information was received after a gap of about 1 week, a clerical and bona fide mistake was committed by the appellant accused in getting the securities credited into the SGL account number 065 instead of account number 032 of the UCO Bank. There was no participation by the accused in any conspiracy to benefit accused number 3, Harshad Mehta. It was purely a clerical error that occurred in a casual way without any bad intention. In a normal way, the accused signed the covering note dated 13th April 1991, also signed by accused number 2, enabling the RBI to credit the securities into SGL account number 065. The accused appellant had no malified or dishonest intention to commit any fraud or cause loss to the UCO Bank or to cheat it. The mistake happened mechanically without the conscious involvement of the appellant. It is also evident from the record that accused number 2 himself admitted in his statement under section 313 CRPC that it was he who struck off account number 032 and wrote account number 065 in the covering note EXT 300. Thus, the appellant cannot be charged with a severe punishment for a reasonable clerical mistake. Learned counsel also submitted that the appellant was not concerned with the routine work of the Hammam Street branch of UCO Bank. He was specially entrusted the duties of redemption and reconciliation of securities. While discharging those duties, when the appellant noticed the mistake, he immediately facilitated transfer of rupees 2 crores on 15th July 1991 from the account number 065 to account number 032 to set right the record. Learned special judge has failed to appreciate the fact in a true spirit that the SGL transfer forms concerning the securities sold by Harshad Mehta to the tune of rupees 15 crores from SGL account number 065 were not signed by the appellant and the appellant has no role in that transaction. This fact itself clearly establishes that the appellant was not part of any conspiracy with accused number 3, Harshad Mehta. But the special judge took a different and wrong view and erred by holding that the appellant transferred securities worth rupees 2 crores lying in the account number 065 to account number 032 to cover up the transaction. There was no evidence on record to establish a link between the accused appellant and the accused number 3, Harshad Mehta, forming a conspiracy between them, and the prosecution has utterly failed to prove this aspect, and therefore the appellant is entitled for benefit of doubt. Further contention of the learned counsel is that the appellant was only an assistant manager of the bank and scrupulously implementing the decisions taken by his superiors. Mr. K.M. Sinha, learned senior counsel appearing for the appellant, submitted that this court has held that the beneficial provisions of the Act are to be applied only for the purpose of interpretation of the Act and not for arriving at a conclusion whether a person is juvenile or not, and the question whether an offender was juvenile on the date of commission of the offence or not is essentially a question of fact which is required to be determined on the basis of the materials brought on record by the parties. He submitted that this court has further held that Section 35 of the Evidence Act, which provides that an entry in a register maintained in the ordinary course of business by a public servant in discharging of his official duty or by any other person in performance of a duty specially enjoined by the law of the country will only apply if the conditions mentioned in Section 35 are fulfilled. He submitted that Section 35 of the Evidence Act could not be applied to the entry of date of birth of respondent number 1 in the school records produced on behalf of respondent number 1 before the trial court and on the evidence as produced. The trial court rightly held that the date of birth of the respondent number 1 cannot be believed to be 5/10/1988. He submitted that the trial court, after scrutinizing the evidence, has held that the evidence produced by respondent number 1 have been created for escaping conviction for a grave offence such as murder and was not believable, and by physical appearance respondent number 1 looks to be over 18 years of age, and on 11/7/2004 he was an adult and not a juvenile. He submitted that this finding of the trial court on a question of fact with regard to the age of respondent number 1 could not be disturbed by the High Court in a revision. In support of this proposition, he relied on Seethamani Rao versus State of UP 1986 4 SCC 447, in which this court has held that the High Court, while exercising its jurisdiction under Articles 2 to 6 and 227 of the Constitution should not interfere with a finding of fact of the inferior court or tribunal, except where the finding was perverse and not based on any material evidence or has resulted in manifest injustice. He submitted that in this decision, this court has further taken the view that if the trial court came to a conclusion which was possible on the evidence, the High Court will not disturb the conclusion arrived at by the trial court merely because the High Court is of the view that a different conclusion is also possible on the same evidence. He vehemently argued that the High Court has lost sight of these limitations of its jurisdiction and on the basis of its own appraisal of the evidence taken a view that the respondent number 1 was a juvenile on the date of the commission of the offense and has set aside the order of the trial court.